to the affidavit of the first respondent. My Lord, even if someone was to say that, the annexure is identified as TD, because he has a mention of, he attaches it as TD in his evidence, but when he brings it, it is marked A. Even if we are to, this court was to take that annexure is TD, my Lord, it offends rules 8 and 9 of the Commissioner for Oaths rules. For the fact that it was not sealed and commissioned by the Commissioner for Oaths. My point, my Lord, is that Annexure 3 attached to the affidavit of the respondent is not sealed, is not commissioned, and it offends rules 8 and 9 of the Commissioner for Oaths rules. My Lord, sealing and commissioning of documents is not a matter of choice. Sealing and commissioning of documents is not a matter of choice. It is a command of the law under those provisions that I have just cited. My Lord, in Egypt Air Corporation, this authority is on page 158. 158. The holding is on 160. In Egypt Air Corporation versus Safish International Food Processing Limited and Pan World Insurance Company Limited. The Supreme Court, my Lord, had this to say. We would like to point out that sealing and marking annexures to an affidavit is a legal requirement. Supreme Court. It is a legal requirement. Which inter alia facilitates the easy identification of annexures, and in our view, the procedure must be adhered to. The procedure must be adhered to. First, my Lord, the annexure in evidence is not identified. But even if we say that it is identified as TD, it is not sealed and commissioned. And the Supreme Court is telling you, you must adhere to those provisions which command commissioning and sealing of annexures. My Lord, that position was restated. That position was restated. If you go on page 165. Yes. Yes, my Lord. I'm obliged. I am obliged, my Lord. My Lord, if non-identification of the parking list by the first respondent has not satisfied you, and non-commissioning has not satisfied you, my Lord, this annexure has a second defect. It is a document belonging to the second respondent. It is a document belonging to the second respondent given to the first respondent. And my lord, that makes it a public document under Section 73 of the Evidence Act. The record, my lord, reflects that that document is not certified. That document is not certified, and therefore cannot be admitted in evidence in accordance with Sections 75 and 76 of the Evidence Act. My lord, in cross-examination, when the first respondent was asked why the document is not certified, he said it is a technicality that his lawyers would answer to. My lord, there is no technicality in certifying public documents. The petitioner had 29 documents to certify, and she certified all of them. The respondent had just one, the parking list, and he refused to certify it. My lord, that put it far away from admission in accordance with Sections 75 and 76 of the Evidence Act. My lord, in Betty Centam versus Naivale Sylvia, in Betty Centam versus Naivale Sylvia, my lord, this authority is on page 169. Same volume, my lord, volume 1. My lord, the holding is on page 189. It was held, my lord, that in the circumstances, a public document ought to be proved as required by the law. The said document cannot be validated because it is an attachment to an affidavit. It cannot be validated simply because it is an attachment on an affidavit, or it was obtained from from a respondent who has not certified it. My lord, I will stop there. The decision is very long. There is no evidence on the part of the respondents that at least they tried to write to the second respondent to have the document certified. There is no evidence of proof of payment. There is no evidence that they tried to make an effort. It is not certified, my lord. My lord, if the first leg of this objection did not satisfy you, this one should. And we pray that that document is struck off the record of the court. The third objection, my lord, is in respect of the oath of Nalukoola. The issue with this one, my lord, it became apparent during cross-examination that this witness did not take the oath. It became apparent during cross-examination that this witness did not take the oath.